Litigant cannot seek recusal of a judge on the ground that he and she may not get a favorable order. Supreme Court. A litigant cannot be permitted to browbeat the court by seeking a bench of its choice. The Supreme Court observed while rejecting a plea seeking recusal of Justice D.Y. Chandrachud from hearing a case. The court observed that a litigant cannot seek recusal of a judge from hearing his or her case on the ground that he and she may not get a favorable order. This case arose from a domestic violence complaint before Metropolitan Magistrate Bengaluru, which was dismissed. The appeal against this order was dismissed by the Additional Sessions Judge Bengaluru. The High Court also dismissed the revision petition filed by the petitioner. The petitioner assailed this order passed by the High Court by filing a writ petition under Article 226 with a prayer to declare the judgment of the single judge void. Later, this writ petition was transferred to Apex Court. The Supreme Court bench comprising Justice D.Y. Chandrachud and K.M. Joseph, in its order passed in September last year, held that the writ petition under Article 226 of the Constitution would not be maintainable in order to challenge an order which has been passed by the High Court in the exercise of its judicial power. While her application seeking to recall the order was being considered by the bench comprising Justice D.Y. Chandrachud and M.R. Shah, the petitioner who appeared in person submitted that Justice Chandrachud should recuse himself from hearing the present application. Justice Shah, who authored the order, observed, "We see no valid and good ground for recusal by one of us merely because the order might not be in favor of the applicant earlier. Cannot be a ground for recusal. A litigant cannot be permitted to browbeat the court by seeking a bench of its choice. Therefore, the prayer of the applicant petitioner person that one of us, Dr. Dhananjay Y. Chandrachud, should recuse from hearing the present miscellaneous application is not accepted and the said prayer is rejected." Observing this, the bench dismissed the application seeking recall of the earlier order. The court noticed that earlier one other application was filed by the applicant for the very relief to recall order was lodged by the registrar, and the application challenging the order of the registrar lodging the application was dismissed. In a judgment passed in August 2019, Seema Sapra versus Court on its own motion, the Supreme Court had observed that a judge can recuse at his own volition but need not at the mere asking of a litigating party. In October 2019, the Supreme Court rejected the prayer for recusal of Justice Arun Mishra from heading the Constitution Bench, formed to settle the interpretation of Section 24, Clause 2 of the Right to Fair Compensation and Transparency in Land Acquisition, Resettlement and Rehabilitation Act. Justice Mishra, who authored the judgment, observed that non-recusal is an interest of justice and he would be committing a blunder if he recuses from the case. The judge also added that recusal cannot to be forced by any litigant to choose a bench, and it is for the concerned judge to decide a recuse. In its order dismissing Harsh Mandey's plea recusal of the then Chief Justice of India Ranjan Gogoi from hearing the Assam detention centers cases, Supreme Court observed that a litigant should not be permitted and allowed to question a judge on perceived bias during the course of hearing. A five-judge bench of the Supreme Court, which heard the batch of petitions challenging the National Judicial Appointments Commission, had rejected the plea seeking recusal by Justice Jagdish Singh Kehar. Cases Neelam Atawar versus Manmohan Atawar. Thank you.